about 10 a.m., so I'm going to get started. Question for everybody here, does it help for me to use a microphone?
Yes, please.
Yes, okay, so I'm going to use a microphone. If my hand goes down, somebody holler, okay? Okay. Before I get started, needed 2 hands. There are 2 handouts. Did everybody get those? Okay, one has staple and then one is very small print and double-sided. Don't expect anybody to be able to read it. I'm having trouble reading it. Okay. Okay. So we are going to get started. We are a smallish group, so I think that we can sort of ask questions as we go. So people feel free to ask those questions, and some of them I might have to put off until later, you know, depending on where they fall in terms of the presentation, but we will make this work. We're going to cover the 4th Amendment in 2 hours, which is just nuts. I will tell you a little bit about myself in a second, but I used to be a law professor and I used to teach criminal procedure, and I used to teach the 4th Amendment in something like 40 hours of lecture, and I felt like that wasn't enough. Okay, so we're going to try and do it in 2 hours, very, very compressed. Okay. So there are definitely some things I'm going to be leaving out. Let me sort of say that at the outset, okay? But my hope is that we can take a break. If you need to step out, just step out, you know, and for a small group, we can make that work. Okay, let me get started. Who am I and why am I here? My name is Kathy Swedlow. I am a longtime resident of the Bailey neighborhood. I'm also a lawyer. I've been doing, I've been working as a lawyer for about 33 years at this point in time. I've had a bunch of different jobs, but most of my work has been associated with public defense and certainly criminal defense. And so I have been working on issues associated with the 4th Amendment and criminal law for most of that time. I'm a member of the East Lansing Independent Police Oversight Commission, and in that capacity, I had talked to my colleagues and I said, you know, wouldn't it be great if we had a training on the 4th Amendment? And so we've got some of my colleagues here today, others couldn't make it, and so we're recording. But as you'll see, the 4th Amendment guides what police do, and so it's important for us in LEPOC to know about that work, okay? So I'm just gonna get started. You all have the slides. I know that you'll probably have some difficulty reading what's on the slide, but I will be reading back to you, okay? Okay. So start out with the question, why study the 4th Amendment? And I know this is difficult to read. These are some statistics I pulled off the Bureau of Justice statistics about how many of us interact with police on an annual basis. This is information that's provided publicly and it's updated routinely. I find it kind of fascinating. But if you take a look at this, okay, according to these statistics, we have so many people in this country, 265-440-600, and it says that in the year that these statistics are accurate, so that's 2022, about 18.5% of us interacted with police in one way, form, or another. So, you know, even if you're not part of an independent police oversight commission, even if you don't study police in that way, that statistic says to me that most of us are going to interact with police. Or a significant chunk of us are. And so it's important to know what your rights are and know what the law says. So I think that's kind of the first reason to study the 4th Amendment. Another reason to study the 4th Amendment, and this I think is particularly germane to those of us who are doing police oversight work, is because the Supreme Court says the 4th Amendment is what guides whether or not police use excessive force in their work, okay? This is a case called Graham v. Connor, and down at the bottom, I put the case names here. You'll see that there are a number of case names throughout these slides. Most of them, I think with 2 exceptions, are from the US Supreme Court. And the reason I wanted to put them on the slides is so that you can look them up. It's 2025, you can Google anything, right? And so you could read these cases if you want to. So this is a case from the US Supreme Court where the court says, look, this case requires us to decide what constitutional standard governs a free citizen's claim that law enforcement officials used excessive force in the course of making an arrest, a stop, or another seizure of his person. And the court says, we hold that such claims are properly analyzed under the 4th Amendment's objective reasonableness standard. So the second reason that you want to be looking at the Fourth Amendment is because this is what guides excessive force. And even if you're not doing ELIPOC work, I think we've been reading a lot about excessive force and learning a lot about excessive force in recent years in terms of the news. Okay, so what guides everything? And we're going to go back to 7th grade a little bit here. Sorry about this. We're going to talk about the U.S. Constitution. U.S. Constitution guides the Fourth Amendment. The Fourth Amendment is part of the Bill of Rights. It's one of the first 10 amendments to the Constitution. Okay? And the U.S. Constitution is the floor for the way the government interacts with us. Okay? By its terms, the U.S. Constitution only applies to federal actors. Okay, and when we're living in East Lansing, we're dealing with the East Lansing Police, so those are local actors, non-federal actors, or we're dealing with the state police. Okay, very few of us are going to deal with federal marshals. But the U.S. Constitution deals with federal actors. However, the Supreme Court has interpreted many of the provisions of the Bill of Rights to apply to the states. Okay, so the Fourth Amendment, even though it's part of this document governing federal actors, does apply to the states. But we also have, on top of that, the state constitution and local laws. And so the question of what does the Fourth Amendment require, what does it restrict, what does it say police can do and cannot do, is really going to be guided by all of these sources of law. The federal constitution is the floor. The state constitution and the state laws, the state can always offer more rights to its citizens than the feds do. And then we have policies and procedures and ordinances in East Lansing. And you put them all together and they are going to guide how the Fourth Amendment applies to us, okay? I'm looking at my friend Mike McDaniel over there, who is a con law professor, and I'm thinking, he's thinking, I just butchered con law, right? Thumbnail sketch of Fourth Amendment. Okay, so let's go right into the Fourth Amendment. Okay, this is the text. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. No warrant shall issue but upon probable cause, supported by oath or affirmation, particularly describing the place to be searched, the person or things to be seized. Okay, that's the text. It's broken down into two parts. Okay, the first part is what we call the reasonableness clause. The right of the people to be secure in the persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. Does that make sense to you? Pardon me, Mayor?
What's reasonable?
Well, what's reasonable, but before we get into the question of what's reasonable, what's a search, right? Okay, I mean, this text, and I think you're right in terms of what's reasonable, this text refers to searches and it refers to seizures, and it never defines what they are, okay? If we did know what a search was and a seizure was, we don't know what's reasonable or unreasonable, okay? Am I standing in the way you can see this here? What's the other problem? Anything jumping out at you when you look at this? You have a right to be free from unreasonable searches and seizures. If we could define what a search was, if we could define what a seizure is, and we're going to talk about that today, and if we could define what reasonability is, then what? Your rights shall not be violated. What if they are? What are we going to do about that? The text of the Constitution doesn't say anything about that, okay? It's kind of a problem, and that's why we study it, okay? So what does it mean to not be violated? That's the reasonableness clause. We also have the warrant clause. And the warrant clause, as I read it earlier, no warrant shall issue but upon probable cause, supported by oath or affirmation. And we'll go into it some more there. But what I want to do now is focus on the reasonableness clause, really. Okay. Now, when we talk about the way to analyze a Fourth Amendment problem, right, if we've got a set of facts in front of us, there are three main questions you need to ask. First of all, was there a search or a seizure? Second of all, if there was a search or a seizure, was it reasonable or unreasonable? And then third, if there was an unreasonable search or seizure, then what's the remedy? Okay? Now, it's really important as we go through these slides and we talk about the facts, we're going to talk about some hypotheticals, to keep in mind that the Fourth Amendment only cares about unreasonable search and seizure activity. If you have an interaction with a police officer and it does not meet the definition of search or does not meet the definition of seizure, the Fourth Amendment doesn't care. It can be patently unreasonable, Fourth Amendment does not care. We only care about what falls into this definition of search and seizure, and we also care about what's reasonable or not, okay? Okay, so when I think probably when I went to law school and I started, the first time I took criminal procedure, well, I only took it once. It passed, right? Okay. But when I took criminal procedure, and I remember reading about what a search was and thinking, why do we have to bother studying this, right? This is pretty straightforward because I have a common sense definition of a search in my head. Do you have a sense of what a search is? Right, and if I had a spare hand, it means kind of to rifle through, right? That's what I think about, that's what a search means. That's not what it means necessarily under the Fourth Amendment. It includes rifling through things, but it doesn't have to, okay? So the Supreme Court has given us two definitions of search, and this is the first one. Defendant has to have exhibited a subjective expectation of privacy that society is prepared to recognize as reasonable, okay? We lawyers love subjective and objective tests. And that's what this test is. You've got to say, I subjectively believe that I have an expectation of privacy in this area. And then everybody in the room has to agree with me that that is an appropriate expectation of privacy. So it's both of those. Because if you think about it, there can be plenty of things that you might claim an expectation of privacy in, but nobody thinks that that's reasonable. So you've got to have both of those things. Now the way the Supreme Court has interpreted that definition is that there's a distinction between public and private. Okay, this is our first definition. So the Supreme Court says, look, if what you're doing in the world is private, then you can claim an expectation of privacy in it, and people, we are prepared to recognize that as reasonable. But if you're out there in the world doing things, right? If I'm walking down the street with my bag of methamphetamine that is labeled meth, okay, I can hardly claim an expectation of privacy and say, no, this is my private meth, right? But if I want to take this bag inside my house, what I do inside my house is purely private. I think this is the point in time where I should probably warn you that I'm going to use a lot of examples and none of them are true. This bag does not have methamphetamine in it, right? I'm making things up, okay? I just want to make clear. Okay, and also the examples I'm going to give about police, I'm making things up, okay? So we have public versus private. So what does that mean? Where do you have an expectation of privacy, a reasonable expectation of privacy? First, go back to the text of the Constitution. You have a reasonable expectation of privacy in your person, houses, papers, and effects. We all know what a person is, we know what a house is, I think we know what papers are. What's an effect? Anybody have any effects with them today? That's an effect. Eric's holding up a cell phone, right? What's an effect? Does anybody have a bag? Chris, your jacket? Your sweater? Okay, yes, okay, that's an effect. Your crutch, right? Your stuff. That's what your effects are, okay? Is your stuff. And you have an expectation of privacy in those things. Okay, so that's the first place we look, is the text of the Constitution. Oops, I just lost my, hang on 1 second. Just lost my slide here. There we go. Okay, the second place, okay, so if we're talking about a house, and this is something, a picture I think I pulled off of ChatGPT, okay? This is a house, so this is where we have an expectation of privacy. But our expectation of privacy when we're talking about the houses extends beyond the house to something that we call curtilage. The US Supreme Court has said that that expectation of privacy that we have in the house goes to those outer buildings on the property. Now, in the way that we live today, very few of us have buildings, and I'm thinking about our average house in East Lansing where you have, outer buildings around your house. But go back to 1789 where you've got the barn and things like that. The Supreme Court says This is your curtilage, you have an expectation of privacy on that. It extends there. So what you're doing in your house is private, and what you're doing inside this outer building is private as well. Yes?
I need to go back. You said effects. Do you have to own the effect? Do you have to own the object in the effect?
Do you have to physically own it, have a property interest in it? You have to have an expectation of privacy in the effect, okay? So, I will give you an example, okay? Let's say I have a car that I own, that if we were to look up the title, it is in my name. But I share that car with my spouse, okay? My spouse drives around in the car as well. So I think that my spouse can claim an expectation of that privacy, even though he is not actually a property owner of the car, okay? Okay, because why? He claims that expectation of privacy. You, on the other hand, can't say, well, Kathy gave me a ride home one day, so I have an expectation of privacy. No, because you have very limited ties to that car, okay? So the court says expectation of privacy and curtilage. They also say you have an expectation of privacy, and this is a fun case, when police use a thermal imager on the home. We are used to, in this day and age, marijuana being legal, but it wasn't so long ago that it wasn't legal, right? And people growing in their house, let's say necessarily illegally. What happened in Danny Kylo's case is the police took a thermal imager and shown it on his house, and they were able to tell where the heat was coming from. And the question is that a search? Okay, again, go back to those questions that I gave you. We're asking, is there a search or a seizure? Is it reasonable or unreasonable? So our first question we have to ask is, was that a search? And if it is a search, you know, using that thermal imager, then we get into reasonability. The Supreme Court says that's a search. Okay, so it's covered by the Fourth Amendment. Yes?
A guy I knew in college who was an artist, he was, you know, art isn't all that financially rewarding all the time, and this was before marijuana was legalized, so he decided to save some money just for himself and some friends. He started growing marijuana in this one room in his house.
Okay.
And what he was told was that he got busted because the Lansing police or somebody, I don't know if it was Lansing police, state police or what, they were doing flyovers with thermal imaging,
Okay.
and they caught him, and he wound up becoming the guest of the governor for a few years.
Okay, then hang on, I got a slide for that.
That's what?
I got a slide for that, okay. Okay, so this is where we have an expectation of privacy, and then here we are shining the thermal imager on the home. Your question is, what if they fly over the house?
Yeah, it's random searching.
Okay, what if they're flying over the house, and what if I have a patch growing in my backyard, right? Okay, the US Supreme Court says there is no expectation of privacy for those aerial surveillance things, okay? So it's actually not the next slide, it's the slide after, so hang on to that, okay? Where else do you not have an expectation of privacy? The Supreme Court says no expectation of privacy in what we call open fields. So you saw this picture before. Here's my house. Okay, this is my curtilage, this is my outer building. What if I'm across the street? Let's imagine I own all of this land, okay? What if I'm across the street and I own that property and it's an open field, even if I've tacked it with no trespassing signs? And let's imagine in a pre-legal marijuana world, I'm growing my marijuana in my open field, and police walk onto my open field. They ignore the no trespassing sign and they see the marijuana. Can I claim that I have been the victim, let's say, of an unreasonable search? And the answer is no, because the court says it's not a search. What goes on in open fields is not a search. You don't have an expectation of privacy. Even though you own the property, even though you posted the no trespassing signs. Okay, going back to your question, well, I'm gonna get there. I have my slides out of order. Where else do you not have an expectation of privacy? Garbage, abandoned garbage. If you put your garbage in the bin and it's next to your house, and I'm thinking of my own house, our bin is behind a gate and it's next to the house, it's part of the curtilage. I can claim an expectation of privacy in that garbage when it's sitting there. But when I wheel it out on Monday or Tuesday night or whatever day it is and I put it on the side of the street, no expectation of privacy. So in theory, the police could come to my garbage, parked the side of the street, I took this off the city's Facebook page, okay? And they could pull my garbage out and go through it and find something incriminating. And I wouldn't have a leg to stand on in terms of the Fourth Amendment. Why? Because the police taking my abandoned garbage is not a search, so it doesn't have to be reasonable or unreasonable, okay? Another thing where you don't have an expectation of privacy, so it's not a search, dog sniffs in a public place. Okay, the Supreme Court says when the police use a canine to sniff, it is what they say sui generis, and so if it's in public, it's not a search, okay? Now I think we're gonna get to your question, the aerial surveillance, that's it, yes, okay. The Supreme Court in two cases, flying over in a helicopter, flying over in an airplane. Okay, if the police are flying over your property and even if they're using, powerful binoculars to see what's going on in the backyard, that's not a search. And the only implication there is it doesn't have to be reasonable. Okay, does that answer your question? Yeah.
What if they're flying over in a plane using an imager? Using the thermal imagery?
Okay, so I don't have an answer for that. What I would say is that the thermal imaging case that I had up here before Kylo, the thermal imaging technology,
That's what they got my friend on.
right, was not strong enough at that point in time for them to be able to use it for anything. I think if they did that today, I think what I would try and do is package together those holdings and say, look, you're flying over my house, and I understand that that's not a search, but you're using a device on my house that you have said is a search. But there's no case law on it. I think I would make the argument. But at that time, and I don't know what year you're talking about, there had been no holding, okay? Okay, next definition of search, that's our first definition, is going to be, comes from a case called US v. Jones from 2012, where the government obtains information by physically intruding on a constitutionally protected area. A search has undoubtedly occurred, okay? So, what does that mean? Well, first of all, we need the government obtaining information. Second of all, we need them we need to be dealing with a constitutionally protected area. And then third, we need a trespass or a physical intrusion. So, what's a constitutionally protected area? Well, persons, houses, papers, and effects, right? Okay, that's gonna be constitutionally protected areas. So, this is a newer test. It's from 2012, it's older, but it was dormant for a while, they brought it back. It's a newer test, but we do have some applications. One application, using a modern GPS device on a car, okay? In Jones, they actually put the device on the car and they followed around Mr. Jones for, I don't know, a couple of weeks, okay? And the Supreme Court said that's a search. They're getting information by a physical intrusion on a constitutionally protected area, his car, okay? Now, if you think about that definition we just talked about before from Kat about public versus private, this is where it's fun to be a lawyer because the Supreme Court is saying, yeah, we have this test about public versus private, but modern GPS can tell us so much about somebody, right? If you trail somebody with the GPS, it's not the same as walking around behind them and seeing where they go. You can get so much information about a person with modern GPS. And so the court says this constitutes a search. I have another example of this constituting a search. This is a case actually from the Sixth Circuit, so this is from a city of Saginaw. Police chalking tires. Have you ever come back to your car and seen that your tires are chalked, right? Because you're gonna get a ticket, right? Okay. The Sixth Circuit, which is the court right below the US Supreme Court, has held that's a search, okay? They're getting information, how long you're parked, by trespassing, by marking your car, a constitutionally protected area, okay? Okay, and one more example that we've got here, a case called Florida v. Cardenas. Cardenas involved a situation where police walked up to somebody's house with a police dog. This is not a real picture, this is ChatGPT, okay? Look this up. They walked up to the house with a dog, and the dog sniffs on the threshold of the house. And you go to enough houses and eventually the dog alerts. Now the question is that a search? Now, we know that dog sniffs in public places are not searches, right? So how do you get this to be a search? US Supreme Court says, look, you know, if you think about somebody's front step, it is there for people you invite to come up to the door and ring the doorbell and perhaps to come inside, or people to come and see you, maybe you don't invite them all. But there's no license that you give to police to come run drug sniffing dogs in your doorstep. So the court says here, this exceeds any license a homeowner would give to a stranger to walk up to their house. And so even though dog sniffs are not searches, the act of doing this constitutes a search. Okay, so all we've done here is define what's a search. Now we start to get into the question of whether or not the search is reasonable or unreasonable. So we're going to go through search, and then we're going to go talk about seizures next after that. Okay. First step in reasonability is the focus on a warrant. A warrant is a judicially signed document that authorizes a police officer to either search or seize. Okay. That's all that a warrant is. And in order to get a warrant, a police officer has to go through the appropriate steps to obtain the warrant, has to go through the appropriate steps to execute the warrant, and if there is some sort of mistake along the way, okay, then we ask a question of, well, did the officer try and do everything right? And so the good faith exception comes into play, and I'll explain that in a second. Okay, so to obtain a warrant properly, and this is checks and balances, okay? Police are members of the executive. They're going to a member of the judiciary to ask for permission to search to get that warrant, okay? So they've got to, go through some certain steps. First of all, the warrant itself has to be based on what we call probable cause, and we'll define that in a second, okay? The warrant itself has to describe with particularity the place to be searched and the person or things to be seized. And the quote here is from the Constitution itself, from the warrant clause. And it has to be presented to a neutral and detached magistrate. It has to go to that member of the judiciary. So what you're doing as a police officer is you're saying, I have adequate suspicion to believe that I'm gonna find this evidence in this location, or that this person has committed this crime. So judicial officer, give me permission to either search or seize. That's what the warrant process is in terms of obtaining it. So what is probable cause? And probably all of you have heard about this. Here are the definitions from the US Supreme Court, okay? If we're searching, this is the definition we get from a case called Gates v. Illinois. It's a fair probability that certain items are the fruits, instrumentalities, or evidence of crime, and that these items are presently to be found at a certain place. So it's not just, hey, I think Bob is a drug dealer and Bob has drugs. It's what kind of drugs? And where do I think I'm gonna find these drugs? Just, in his house? Where in his house? You can't just sort of have what we call bald and unilluminating assertions. You've actually got to have some specificity. So that's what our definition is for search. For probable cause for a seizure, that a crime has been committed and the person to be seized has committed that crime. Okay. Now, this is where things kind of get difficult. What does that mean in operation? The Supreme Court has said it's a fluid concept. They've said it's based on the totality of the circumstances. And one of the things I think is important to recognize when we're dealing with probable cause is a lot of times police are dealing with tips. Raise your hand if you've been pulled over for speeding or any sort of moving violation. Okay, most of us. And how did that happen? Did somebody call into the police and say, there's somebody who drove down my street? No. You're shaking your head no. Okay, so your light was out. So let's take that and whether that was a good idea or not, the officer saw a car driving with a light out. Okay, right, and we can talk about, okay, but let's imagine there is some state law or some municipal law that says you gotta have a light on, and your light was out, okay? So the officer had probable cause, why? Well, because he or she witnessed it himself, okay? And I think about all of the speeding tickets I've gotten in my life, and I've gotten a number of them. Every single one of them, I drove past an officer. right? And they saw me speeding, or I rolled through a stop sign. Okay, so they see it. So when we talk about the definition of probable cause, we're not questioning, did they really have probable cause? Of course they did. But a lot of times when we're talking about policing and we're talking about the criminal law, police get information from third parties, from tips, right? And the question is, how do you use that information in the calculus? And it's a bit of a difficult question, okay? Or a handful of things that the court looks at is this information public or private, okay? So if police get a tip from somebody who says, well, let's hold on to the example. Public or private information is, do we have predictive detail? And then the third thing, the Supreme Court says, no bald and unilluminating assertions, okay? Let's imagine that police get a tip saying, at noon, there will be a middle-aged woman with shoulder-length hair, wearing black pants and a blue top, and she's got a black coat, and she's gonna be leaving the Hannah Center, and she's gonna have methamphetamine in her pockets. Okay, there's a tip. Okay, it's predictive, it's predicting that something's gonna happen in the future, but if you think about that tip, it adds up to nothing, right? That's information that any of you could call in, you could give a physical description of me, and just add the tagline, and she's got meth in her pockets, right? Okay, so what the court is looking for in terms of tips is information that could only really come from somebody on the inside, right? And so they don't want what they call these bald and unilluminating assertions. They want something more than that, something more than anybody could see, okay? It's hard to pin down. It really is hard to pin down. And, you know, I think I'm not the only crim law or crim procedure professor who said probable cause is like pornography. You know it when you see it. It's a great line. It really works, okay? But if you think about your own life, times that you've received information that, you know, somebody thinks is suspicious, there are times when you go to that information and go, there's nothing to that. And then other times you say, hey, that kind of hangs together. Somebody on the inside knows something, okay? Now, how does that work out in terms of suspicion? Here's a suspicion scale, 0 to 100. Where do you think probable cause falls here? If 0 is zero suspicion, and 100 is the police officer saw me speeding, where's probable cause? It can certainly go to 100%, right? If that officer does see me speeding, it can go to 100%. But where do you think it can go in terms of how low? Pardon me?
Above 50%.
Okay, so I think a lot of us want to go to 50%, right? Because probable, we're talking about probabilities, right? More likely than not. And the more likely than not standard is a legal standard we use called preponderance of the evidence in civil cases. And I think a lot of times we want to tie probable cause to something a little bit nudged over that. Other ideas? No? I will tell you that the case law, well, here's what the Supreme Court says about this. The Supreme Court has been asked multiple times, put a number on it. They refuse. Probable cause standard is incapable of precise definition or quantification into percentages because it deals with probabilities and depends on the totality of the circumstances. So every time they're asked to put a number, did this just die?
Yes.
Every time they're asked to put a number on it, they punt. Okay, and you know, if you look at the case law, I was reading an article, thank you, earlier this week. Does this work? Nope. Okay. You are, okay, this one works, okay. I was reading an article earlier this week, and it was collecting cases where, from around the country, where various state Supreme Courts have said, we have probable cause in this instance, but if we were to add it up, it'd be just under 50. Okay, so you can't put a number on it, as tempting as it is. Yes?
I'm thinking about the pulling over a car and a regulation is broken, you know, the light is out. And there was a time where police officers would maybe pull somebody over and say, hey, your light is out, I just want to let you know, right? And
Yep.
that would be okay. But then they get to the car and there's something suspicious. And what goes back is, why'd you pull them over in the first place on a little light? And then you start chipping away
Yeah.
at all of this
Yeah.
stuff. How does that play in?
Okay. So what you're talking about is the officer's use of discretion, right? The discretion that the officer employs to say, hey, look, I'm gonna make the choice to pull this person over, or I'm gonna choose not to. How many of us believe that if we're only driving 5 miles over, they'll never pull us over? I mean, come on. And that's I drive to Detroit all the time, that's what I
Can I
think.
ask a quick question?
Yeah.
Is pulling someone over a search or seizure?
Okay, yes, so pulling somebody over is a seizure. Okay, so we're going through the search stuff now, so pulling somebody over is a seizure, so it has to be reasonable. Okay, so let's go back to the example we've been given, a light is out over something on the back of the car. That is a violation of whatever ordinance, okay? So when the officer makes the choice and says, I'm gonna pull this person over, that is a seizure, and what makes that seizure reasonable is because there's been a violation of the law, and the officer then has probable cause to believe that that person has violated the law. Why? Because they saw it with their own eyes. Now, there's a larger question that says, do we want officers to be exercising discretion in that way? And that becomes a different conversation. But in terms of the Fourth Amendment, stopping somebody for that, that's a seizure, and it's reasonable, okay? Makes sense? Now, part of your question is, what happens when then one thing leads to another, leads to another, leads to another, okay? We're gonna get into some hypotheticals once we get some of the law out of the way. But one of the things that you're gonna see is these situations with police officers are very fluid, okay? And we can start with one thing and end up with something else. And the law, at least from the Supreme Court, is that's okay as long as the officer is not violating the Fourth Amendment, okay? So let's imagine I see you speeding and I'm a police officer and I choose, well, I don't wanna make you're the police officer. You see me speeding, you choose to pull me over, okay? And there it is, you pull me over, and as you come up to my car to ask for my license and registration, guess what? I've got my bag of methamphetamine sitting on my lap, and it says methamphetamine. That traffic stop has turned into something completely different, right? Okay? What the Supreme Court says is, you as the officer need to have the discretion to deal with the situation as it comes to you, because at least according to the Supreme Court, we don't want to tie the officer's hands. We don't want you to be in a situation where you're like, well, I pulled her over for speeding, I guess those 2 pounds of meth, oh well, right? You need the flexibility in order to deal with those drugs, okay? Okay, yes?
Oh, I've got a really interesting one for
I
you.
know you do.
I live on the east side of East Lansing.
Okay.
We go to Barnes and Noble on the west side of Lansing every Friday night. We get off the freeway at Frandor. We drive on Kalamazoo and cut through campus to get home. I'm driving on Kalamazoo Avenue, just south of those apartments there. And all of a sudden, a campus cop pulls me over. Now, it's my understanding that campus cops are deputy sheriffs of Hingham County. Okay, I figured I must be speeding, which would be legitimate if she had a radar in the car, okay? So she tells me that, I give her my license and my registration, and she tells me that there is no record of my car being registered right then. As it turned out, it was because the Secretary of State screwed something up with the insurance on the car. So even though I had a license plate with the proper tab and I had the proper registration in the car, her records on her car computer were saying that the car was not registered and I was driving illegally. And she looks at me and Cynthia and she says, I should really impound your car right now. She goes, that's what I'm supposed to do. But she looks at me. She's looking at 2 boring white people in their mid-60s in a boring sedan who live in a nice neighborhood. She goes, well, I'll let you go, but you better deal with this tomorrow. All I could, and so I said to her, well, wait a minute. Am I getting a speeding ticket or was I driving erratically? It turns out that she had pulled me over not because she had probable cause I was breaking the law in some way, she had a scanner on her computer that looked at every license
Right.
plate.
We currently do have an issue, well, there is a scanning technology that can look at every license plate. And the question is, if we're examining every license plate, is that reasonable or not under the Fourth Amendment, okay? And the question is, what about the viability or what about the reliability, excuse me, of that technology, right? So if we have the technology that's scanning every plate, and let's imagine, and going back to the Secretary of State's database and scraping it to figure out, who's registered and who's not. If there is a significant error rate in that, and police are relying on that technology to make stops, is it reasonable or not? Okay, and again, within the rubric of what we're talking about, is there a search? Is there a seizure? If there is it reasonable or unreasonable? And I think that when you're talking about significant error rates in those types of technologies, then you can get into questions of it being across the board unreasonable. But that's more of a systemic challenge, okay?
Well,
But can I continue
But let me
here?
say
Okay.
one last thing,
Okay.
that, like I said, we're two boring white people, in our mid-60s, who live in a nice neighborhood from the driver's license, and all I could think of was a number of black people I've known, including a former state trooper, who have told me horror stories about being black and how they were treated by the East Lansing police.
Okay.
And she had been saying, I'm really supposed to impound your car. All I could think of was, what if we weren't who we are?
Okay. I'm not trying to cut you off, I'm trying to get
I'm
to the
done.
Fourth
I'm
Amendment
done.
here, okay? So these are great questions to ask. What I want to do is give you the groundwork for the Fourth Amendment so we can have those discussions. So this is probable cause, okay. So we know to have a warrant, it's got to be based on probable cause, okay? We also know that it's got to be presented to a neutral and detached magistrate, but then the officer has the warrant in hand. And the warrant is the legal document that says you get to search in this location and look for this or that, okay? So how do you execute the warrant? Now, this is another, I think, can be a very controversial topic, okay, in terms of how the warrant is executed. The Supreme Court, and I'm gonna see if I can get up here. The Supreme Court says, when we talk about execution of warrants, we get into questions of should the police knock and announce their presence before entering a private home? Can they come into the house only during daylight hours, or can they come in the nighttime? And then, once we get rid of not going to announce in time of day, what about other factors regarding reasonableness? Now, we've all read stories in the news, and I'm thinking of a couple, where police dispense with knock and announce, or were serving nighttime warrants, and there are some horrible tragedies. Absolutely, okay? I don't think there's a straightforward answer here. I think it's a very difficult question. In the time I spent teaching Crim Pro, I had a lot of police officers in my class, and I had police officers who would say, absolutely, we need the ability to have no-knock warrants, and we need the ability to have nighttime warrants. I've also known police officers who say, no, no-knock warrants don't keep me any safer, and knock and announce is an important requirement, okay? I don't have those boots on the ground, but this is certainly a debate that's going on. I don't know if anybody followed our last legislative session. There was an attempt to get rid of the no-knock warrants in Michigan. That legislation didn't advance. I think Grand Rapids has dispensed with no-knock warrants. The Supreme Court's position on this, the US Supreme Court's position on this is it's all about reasonableness. And if in any given situation a police officer can say, I needed to go in the dead of night, or I needed to dispense with knock and announce, and if the Supreme Court thinks that's reasonable, they're fine with it. That's the US Supreme Court's approach. But we also have a state constitution, and certainly we can provide greater constitutional rights statewide than the US Constitution requires. Because again, the US Constitution is a floor, it's not a ceiling. Okay, what happens if we get it wrong? Okay, this is something called the good faith exception. Go back to what I told you about warrants. A police officer is saying, look, I think I have probable cause. I think I have adequate suspicion to go search in this particular place. I'm gonna come to a judicial officer, a magistrate, and get a signature. The magistrate's gonna give me the warrant. I'm gonna go execute that search. What if they're wrong? What if the magistrate got it wrong? and the officer didn't have probable cause? Or what if there's a mistake in the warrant that's essentially fatal? What happens then? Okay, and the officer collects up a bunch of evidence. The Supreme Court says there's something called the good faith exception. If there's a mistake in the warrant process, either in terms of what the officer did, okay, or in terms of what the magistrate did, and if the officer himself or herself is acting in good faith, the Supreme Court says that's okay. Okay, why? Because the officer tried to get it right. And you know, I think you can extrapolate to your own lifetime experiences or work experiences when there have been certainly times in my life where I've tried to do everything right and got something wrong, and I don't think I should be punished. And then there are times when I cut corners and I should pay the price for that. And that's essentially what the good faith exception is, okay? Now we're gonna get into the fun stuff, okay? Think about where we are. We're talking about, is there a search? We're gonna get to seizures in a bit. We're talking about what's reasonable or not. And one thing under reasonability is a warrant or not. But what if there's no warrant? And for the most part, there are more times when police officers can act without warrants than times that they need to go get warrants. And we're gonna talk about a handful of these exceptions, okay? When I was teaching Crim Pro, I used to teach, I think, about 18 or 20 exceptions. We're only gonna talk about some, okay? Times when officers don't need to get warrants. Top one, most obvious one, is what we call a situation-specific exigency, an emergency situation where the officer doesn't have time to get a warrant. Now, this exception, was created at a time before we lived in the digital age. In the world that we live in today, it's relatively easy and relatively quick to get a warrant. Why? Because think of the way that people are interconnected. But in a fully paper world, going to get a warrant was a laborious process, okay? And so this law has developed around that. The Supreme Court says, look, here, you can have an exigency in any type of situation, but these are the most common ones, times when police officers don't have to get warrants. What we call hot pursuit of a fleeing felon, imminent destruction of evidence, right? If police officer is chasing me and I'm tossing the evidence and throwing out, he doesn't have to go get a warrant, right? He can grab that evidence. Need to prevent a suspect's escape, or what the court calls a risk of danger to police or others. This is a really fact-specific type of situation, and you really kind of need to drill down into the facts to figure out whether or not you have a legitimate exigency. But the rules about exigencies are the police can't create them. They've got to be inherent to the situation, right? I can't, as an officer, throw up a smoke screen and then say, oh, emergency, don't have to go get a warrant. They've got to be inherent to the situation. And when the exigency ends, the right to rely on the exception ends as well. Okay, so the officers are responding to an exigency as opposed to creating one. That's one exception. Another exception, and we talked about this, believe it or not, is something called plain view. Think about an officer who is going down a certain path. In our example, remember, you were pulling me over? You were pulling me over for speeding. That is a moving violation. Guess what? You pulled me over for speeding, and as you approached the car, you saw the drugs in my lap. And so the situation turned into something else. Should you as an officer be required to say, no, I don't see those drugs at all because this is a speeding stop? Obviously not. The Supreme Court says not at all. There's something called plain view. If the officer is legitimately doing his or her job and comes across something else, then they can take that evidence. That is what we call plain view, okay? So plain view has three, we're gonna get here, requirements, okay? First of all, the officer has to be in a lawful vantage point to view the evidence. And I don't know if you can see up here, but I've got view in quotation marks. The plain view exception extends to other senses as well, okay? So it could mean plain smell, okay? It could also mean plain touch, but they've got to be in a lawful vantage point, essentially doing what they're allowed to be doing within the limits of the Fourth Amendment, okay? In order to get to that evidence, they can't engage in a further search activity. And I put search in quotation marks because we're talking about search as we've defined it earlier. And then they've got to have probable cause to believe that the evidence that they see is actually evidence of a crime, okay? So go back to my example, you pull me over for speeding, there's a bag of meth on my lap, it's labeled bag of meth, okay? Do you have probable cause? Absolutely, okay, do you have to search to get to that evidence? No, it's right there, right? Okay, so you can see it. And are you in a lawful vantage point? Yes, you pulled me over for speeding, right? So you can take that evidence because it's in plain view. Now change those facts a little bit. Hang on one second, change the facts, hang on one second. A bit. Let's imagine you pull me over for speeding, and as you're handing me the ticket, you're like, you look like the kind of gal who's got meth in your car. Okay, so let's pop the trunk. I want to search that trunk. And I pop the trunk, and there's the bag of meth in my trunk. Okay. Are you in a lawful vantage point to view the evidence? Well, you got me by the side of the road legitimately because you pulled me over for speeding, but I don't think you're lawfully looking in my trunk, okay? Did you have to search to get to that evidence? Yes, I had to pop that trunk, so there's an interference with my expectation of privacy. Do you have probable cause? Yes, because my bag of meth is labeled bag of meth, okay? But that evidence is not in plain view, even though you're seeing it in what we would say colloquially is plain view. Why? Because you had to manipulate the situation to get there, okay? Yeah.
Just because I'm a literal person, you're saying a bag that says bag of meth. They can't actually see the meth.
My
Seems
bag is
like-
clear and it's meth and it's very clear. I'm coming up with a crazy example to prove my point.
Well, I just said, like,
Yeah.
where does freedom of speech end? Or we're writing words, like, I could just put coat of meth addict or something.
Okay, so let's imagine that it says, well, you talk about free speech. The standard that we need here is probable cause. So this officer needs to develop probable cause to believe that what they're looking at is in fact what they suspect it is, okay? If you Google the words bag of drugs, and you go to Google Images, everybody knows how to go to Google Images, you will see there's a whole line of cosmetic bags. Apparently people think this is fun, where you can have a cosmetic bag for makeup and stuff that says bag of drugs, okay? And it says in nice cursive handwriting, it's got rhinestones on it and stuff like that. Let's imagine that the bag that you see says bag of drugs and it's got rhinestones and stuff like that. Do you have probable cause? I think that becomes a harder one because it looks like a cosmetic bag as opposed to something that might be packaged in a way that's indicative of drug trafficking. Okay, so I think you need to take it as you see it, but it comes down to that requirement of having probable cause. It's also important to remember that probable cause is probable. It's not 100% certainty. Okay, so I can develop probable cause to believe that I'm going to find something, I'm going to find drugs in a certain house. Let's imagine I go get a warrant and I fill out the application, I have a detailed application, I submit it to a magistrate, they agree, they sign, I search the house, nothing. Is my search unreasonable? No, you can be wrong. All the search needs to do is be reasonable. So probable cause is not always correct. A lot of times it can be incorrect. Okay, so that's plain view. And I think I've got something here. When we talk about plain view, the discovery does not need to be inadvertent. So a police officer can say, look, I'm executing this search warrant at this person's house. I'm coming for the bank records. But I got a pretty good idea I'm gonna find some cocaine as well, okay? And guess what, I did find the cocaine. That is okay as long as the requirements for plain view are met, okay? So it doesn't have to be a total surprise, okay?
What if you went into the house looking for bank records?
Yep, and
which
I'm
you
just
would-
looking at the time, yep.
You would expect in one place, but then you start going through their medicine cabinet.
Okay, so when we talk about executing a warrant, okay, the warrant itself is a legal document that says, here officer is what you can do, here is where you can search. And so as long as the officer is following what the warrant requires, they're fine. So police officer gets a warrant to search my house for dead bodies. They think I've got bodies stored in the attic. So what they do is they come in the kitchen, they start opening up the drawers. Okay, and they find cocaine in the drawers. Is that appropriate? Is that a reasonable search? No, because unless they're very small people, right, they're not gonna be in the drawers. But if those officers are searching in places where they could find those bodies and come across something else, that's fine. So a warrant is not, you know, a license to go crazy inside somebody's house. The warrant describes with particularity, the officer says, here's what I'm looking for, here's where I want to search. And the magistrate signs off on it and says, here's where you can go, because you told me, and I believe you, that you have probable cause to search in this area for this thing, okay? I just checked my phone, we're at about the hour mark. I'd like to keep going if you guys are okay. Is that okay? Okay, if anybody needs to jump out, you should, okay? So we've got plain view. Consent, okay. Consent, according to the Supreme Court, is a terrific way to get evidence. In the absence of probable cause, you ask somebody to search, and if they're gonna say yes, then that's a great way to get evidence. That's what the US Supreme Court says. In terms of consent, we look for the question that's asked, we look for the consent that's granted, and we look for any revocation of the consent or any sort of limits, okay? So if the officer pulls me over and says, can I search your car? Okay, when you pulled me over for speeding and then you asked to search my car, and I said yes, what have I agreed to? Ideas? Well, search my car, what does that mean? Doesn't include the trunk. Yeah, it does. Okay, the courts uniformly say, can I search your car, includes the trunk. Okay, it's not restricted to what we call the passenger area. Now let's imagine you ask that question, can I search your car? And I say yes, but you gotta stay out of the trunk. Okay, can you go in the trunk? Pardon me?
They're gonna go in the trunk first.
Okay, well, let's take that hypothetical. Can I search your car? That's your question to me, and I say, yes, you may, but you may not search in the trunk. Can you draw an adverse inference from my limits on my consent? Can you say, she doesn't want me in the trunk, that's where I'm gonna go because that's where all the good stuff is? Can you do that? I'm saying yeses and nos, okay. The law says that the officer cannot draw an adverse inference from limitations placed on the consent or from revocation of the consent. But the law also says that the officer can draw an adverse inference on the way that the limitations are placed, okay? So sometimes you will read cases where the officer says, I asked to search the car, the person said, yes, you can search the car, but not the trunk, and then they wouldn't make eye contacts, and they were making furtive gestures, and all kinds of things that seemed suspicious to me. Suddenly, we're not drawing inferences from limitations placed on the consent, but it's the way that the consent is placed, or the way the consent is limited. But the court says this is a good way to get evidence, and the only standard is going to be free from coercion or duress. Now, I think this is really important here. I put up here, a knowing, voluntary, and intelligent waiver is not required. Your Fourth Amendment rights are constitutional rights, and when you consent, you are waiving your rights. It's no different from if you go to court and you plead guilty, you are waiving your right to a trial, or you're waiving your right to confront your witnesses, you're waiving, other rights along the way. When we talk about waivers of rights, the standard of constitutional rights, the standard is usually knowing, voluntary, and intelligent. You know what your rights are, you know, that's knowing. Intelligent means you understand the consequences of giving them up. And voluntary means free from coercion or duress, okay? How many people know what Miranda rights are? Everybody has watched TV, okay? They read you your rights. You have the right to remain silent, here's the cost of giving it up, okay? And if you choose to speak to the police and you sign a waiver form, that is a knowing, voluntary, and intelligent waiver. They told you what your rights are, they told you the cost of giving up those rights, and assuming that there's no coercion or duress, then your waiver is valid. The Supreme Court holds true to that type of standard in every other type of constitutional waiver except for the Fourth Amendment. When we're on the side of the road and a police officer asks to search our car or to search a bag or something like that, the standard is only going to be voluntary, free from coercion or duress. And the reason for that is the court says it's just too difficult to get a knowing and intelligent waiver on the side of the road. It's too difficult. But if you're in court and you're pleading guilty, or if you're in the police station and you're going to be interrogated and you're given that Miranda rights waiver form, it's easier to do in that context, okay? Yeah.
Question.
Yeah.
Well, I'll just stick with one. So a officer shows up at a house, asks to search the house, and says, if you don't allow me to search the house, I'll charge you with harboring. Is that coercion?
That is absolutely coercion. Lots of cases. If you don't consent, I will report you to X or report you to Y. I will take away your kids. I will do this. I will do that. That's coercion. Okay. Physical coercion, use of any sort of physical force is also coercion. But can I search? Sure. Okay. Now, what I would say is I want to start with your example. A police officer comes to your house and says, "Can I search your house? Will you give me consent?" You don't see many cases like that because I think as a prosecutor, I don't want to defend that at all. I think if an officer asks to search your car, that happens all the time. But when we think about Fourth Amendment protections, the home gets the greatest protection. And so when we talk about searching houses, it's with a warrant or a really solid exigency, not knocking on doors saying, "Hey, I'm here anyway, what are you saying? Can I go through your stuff?" No. Okay. Okay. Next type of exception, something called a search incident to arrest, okay? Before we get into the requirements, okay, I'll tell you what this is. Police officer arrests me, takes me into custody, okay? They're gonna take me and put me in the jail. They need to go through my stuff. Who knows what's in my pockets, right? I might have drugs, I might have a weapon, I might have any kind of contraband. And that's what a search incident to arrest is. It is a suspicionless search, meaning they don't have to think I have anything in my pockets, they can search anyway because it's premised on the authority to make the arrest. So the officer has to have what we call a valid constitutional arrest. The search has to be close in time with the arrest, and it's confined to the suspect's area of reach. Okay, we call that the wingspan. I'm gonna put this down for a second, okay? Let's imagine that an officer comes and arrests me right now, and I said, "Well, hang on, my stuff is here." Can the officer search my bag? Right there. Yes, this is my wingspan. This bag is part of my wingspan. Let's imagine my bag, all my stuff is way over there, way in the corner of the room. Can they search my bag? No, because it's not in my area of reach. Okay, when we talk about a search incident to arrest, the point is to make sure that we're not introducing contraband into the jail, but also to make sure that the officer's safe. So if all of my stuff is way over in the corner of the room, there's no chance I can reach for it and hurt the officer. But if my stuff is right next to me, then the officer can search there. Okay. Now, those are, I gave you the example of searching what we call a container, and I've got a duffel bag, but this bag as well. What about this? What if this is in my area of reach? Can the officer search my phone? What do you think? Some yeses and no's, okay. This is an interesting thing with it. The court has recently confronted, by the court, I'm always referring to the U.S. Supreme Court. This phone is no different from this bag, okay? It is a container. It just contains different stuff, and it contains more stuff, my phone does. And the Supreme Court draws a line and says, look, when you're dealing with search as incident to arrest, you can go inside the bag. But when you're dealing with a phone, it's qualitatively different, okay, what a phone contains. And so we can't search phones without warrants, okay? Always need a warrant to search a phone. I'm one of those people who's geeky enough to get state police alerts. I sign up for them, it's really fun, you should try doing it sometime. I got an alert yesterday from the MSP reminding officers, you always need a warrant to search a phone, okay? Now, search as incident to arrest, when we're dealing with arrests from vehicles, and this is an exception that actually shows up a fair amount, okay? The search is gonna be restricted to the passenger compartment of the car. So the officer pulls me over, you've decided to arrest me for that bag of meth, okay? You can search my passenger compartment, you can't go in my trunk. And the search of my passenger compartment is only going to be allowed when I have a chance of accessing the car. These rules get a little fun to play with, okay? Or there's reason to believe that evidence of the arresting offense will be found inside the car. So let me give you an example. you've pulled me over for speeding, I hope you don't mind being my officer over and over again. And let's imagine as part of the checking my license, writing the ticket, you put me in the back of your patrol car, okay? And that sometimes happens, okay? So I'm in the back of your patrol car and you decide to arrest me because there is an active warrant, okay, for failure to pay child support. Who knew? I have cats, but failure to pay child support, okay? So you decide to arrest me. Can she search my car? Incident to arrest. She can search my person, right? She can, my wingspan. Can you also search the passenger compartment of my car? Okay, no, because even though I'm a recent occupant of that car, my car, I have no chance of accessing it, but also what is the arresting offense? Failure to pay child support, right? And so you have no reason to believe that there's, I don't know what the evidence of failure to pay child support is because it's a negative.
Money.
Well, but negative, right, but you're not gonna find it inside the car. But change that to drugs. Let's imagine that you pull me over and you and I are interacting and you ask me to exit the car and I'm standing outside the car. So you and I are standing next to my car, which is over here. And in the course of talking to me, you discover, and just work with me here, you discover that I have drugs in my pocket. So you decide to make an arrest for drugs. For the search incident to arrest, you can search my purse and my wingspan. Can you search the passenger compartment of my car? Do I have a chance of accessing my car? Yes, I'm on the side of the road. And is it reasonable to believe that the car will include evidence of the arresting offense? Yes, because you arrested me for drugs.
How did you get the person out of the car? What's reasonable to ask?
Okay, so how did you get the person out of the car? This comes back to something that we've been talking about sort of all along. Officers have discretion to ask people to exit the car. Court says police officers need the authority to control that situation because they're the ones with boots on the ground. And so the US Supreme Court is never going to say, look, you cannot ask people to exit the car. They say we leave it to the officer. If in your discretion you think that that's the way to maintain safety and maintain control over the situation, you can ask people to exit the car. And I've talked to different police officers and who have talked to any police officer, you'll get a different answer as to what they do and what they think is appropriate under those circumstances. Okay, automobile exception search. We're whizzing through the exceptions because I want to get to some hypos. Okay, actually I want to get to seizure. Okay, automobile exception search is a warrantless search of a car based on probable cause. And there's a string of cases here from the US Supreme Court. This exception is actually 100 years old next March. Okay, the Supreme Court came up with it in 1925. Wow, okay. It is a probable cause based search. If the officer has probable cause to believe that there's evidence of a crime inside the car, he or she can search that car wherever their probable cause takes them. They don't have to go get a warrant. So the scope of the search is going to be restricted by the officer's probable cause. Okay, and the rationales are cars move around and you have a reduced expectation of privacy. Okay, a couple more exceptions and then we're going to get to seizures. Inventory searches. Inventory searches are searches that exist to inventory somebody's property when they are taken into the police station. If I am arrested on the side of the road, okay, and police officer is going to take me into his car and take me down to the jail, I'm getting into that car and I've got my jacket, I've got my purse, I've got my computer, I've got my car, it's filled with stuff. Okay, before we impound all of the property, we're going to take an inventory of it so that later I don't turn around and say, well, where's my missing money? Or I had my valuable diamond jewelry and it seems to be missing. That's what an inventory search is. Okay, we just go through the person's stuff.
What if you found something illegal during that
What
inventory
if,
search?
okay, great question. Let's imagine we're conducting an inventory search. I'm not gonna get to your question, just one second, okay? What controls the scope of the inventory search? An inventory policy. And this is where we're gonna have East Lansing, we're here in East Lansing, but a local policy is going to dictate this. Here in East Lansing, we have an inventory code that says to officers, when you are searching or when you're arresting somebody or impounding a vehicle, here's how you inventory your car. Let's imagine in the process of following that inventory code and going through my car to make sure that there's no, cash lying around or anything like that, the officer discovers my bag of cocaine, which is labeled cocaine, clearly cocaine. What principle that we've talked about would authorize the officer to take that cocaine? Plain view, right? Officers in a lawful vantage point, they're conducting an inventory search, right? They don't have to engage in further search activity that came across it, and they have probable cause to believe that that's evidence of a crime, okay? So that's how the exceptions start to build on top of each other. I think we've got one more here, administrative search. This is a search where we don't have traditional suspicion like probable cause, okay? It's generated from an administrative code requiring inspection or administrative action. We live in East Lansing, what's coming to mind? Right, rental inspections, right? Okay, so if an officer needs to, or not an officer, excuse me, if the housing inspector needs to inspect a property, okay, they can go, think about it, it's going inside somebody's house. It's a government actor entering somebody's house without a warrant and without necessarily consent. I mean, it's part of the lease. What makes it permissible? It's this administrative code that we're going to have that will authorize the search, okay? And if you have an administrative code and the officer is following it, it's perfectly fine. And if I was looking at this yesterday, you can go onto the East Lansing website and you can see the administrative code that authorizes the housing inspector to inspect, okay?
They have to give notice though, don't they?
Pardon me?
Do they need to give notice? Is
Do they
notice part
need
of
to
the
give,
code?
yes, they'll need to give notice, and, you know, there's gonna be a bunch of law outside of the Fourth Amendment that will dictate this. Every lease I've ever signed has some information in there when I was a renter that says the housing inspector gets to inspect, and the landlord's gonna call you, and they make an appointment, and so all of those things are laid out in the code, okay? But if, and this kinda goes back to Kat's question, if we have somebody who is conducting a legitimate administrative search of a rental property, discovers evidence, can they grab it? Yes, under plain view. We're taking those exceptions and we're starting to put them together. Okay, so we've got our exceptions. Then what? Okay, go back to the text of the Fourth Amendment. It says the right shall not be violated. How do you like that? It's a trunk full of drugs. I found that. The internet's an amazing place. Okay. What do? If there has been a search or a seizure, and if it is deemed unreasonable, then what? Because all we know is the right against unreasonable searches and seizures shall not be violated, then what? The remedy is what we call suppression of evidence. We call this the exclusionary rule. And what it says is that the prosecutor cannot use that evidence that's been collected through an unreasonable search. They can't use it to prosecute the person. So if I get pulled over and there's some sort of unreasonable search that leads to discovery of cocaine in my car, and the prosecutor wants to prosecute me for those drugs, they're gonna have to find another mechanism to do it other than relying on the drugs. Those drugs can't be used against me. The reason for this, I think this just died again. Okay, thank you. The reason for this, according to the Supreme Court, is this will deter police misconduct. If you say to the police officers, look, if you cut corners, okay, and go obtaining evidence through unreasonable means, then you don't get to go forward with the prosecution. That's the Supreme Court's thinking. It will deter police from that activity. The court also says it promotes judicial integrity. That's a long path. I just wanted the slide to be complete here, but this is what the court says, okay? Now, the exclusionary rule is a judicially crafted rule. Means that the US Supreme Court made it up. When you saw the text of the Constitution, you didn't see the exclusionary rule. They made it up, and that means that they can decide when it might not apply. So there are times where the Supreme Court says, yeah, you got that evidence through an unreasonable search, but we'll allow it in anyway. Okay, that goes beyond the scope of what we're talking about here, but just so you know about how that works. Now, the next thing we're gonna talk about is we're getting to seizures, we're real close, is something called the fruit of the poisonous tree. What happens when police go to one house? We go to Blue House. We search the house unreasonably. Let's imagine no warrant, no probable cause, just the most unreasonable search ever. But officers are gonna search this house and they're gonna find drugs. And based on what they discover at Blue House, they're gonna start to suspect that they can search Aqua House. And so they go and they search Aqua House. Okay, and as part of the search for Aqua House, they discover some more drugs. And then this happens again and we go to Pink House. Okay? Under the fruit of the poisonous tree doctrine, all of these drugs have to be suppressed. We can't use these drugs against this guy, these drugs against this guy, or the drugs on the far right against the Pink House, person who's in the Pink House, because each is a fruit of a poisonous tree. And the reason I have these black arrows here is because what we would describe this as a but-for causality. But for the bad search at Blue House, you never would have gone to Aqua House. And but for the bad search at Aqua House, you never would have gone to Pink House. So all of that evidence gets suppressed, okay? If we can trace a but-for causality, everything goes out. But if there's something that ruins the taint, if we break that taint, there's someplace in there, then some of the evidence, some of the evidence can be used. Okay, now, let's get to seizures. I want to get there. Okay, think about where we were. 3 questions. Was there a search or a seizure? Reasonable or unreasonable? What's the remedy? We've talked about this in terms of search. I want to talk about this in terms of seizures. And it's a lot easier, but we needed to go through the searches before we get to a seizure. What is a seizure? The court has a handful of definitions. First definition, when an officer accosts an individual and restrains his freedom to walk away, okay? Officer walks up to me and puts me in handcuffs. Am I seized? Yeah, I mean, that's really the easy stuff, okay, if the officer's going to handcuff me. What's harder is the officer walks up to me and there's some sort of interaction. How much pressure needs to be put on me before I'm in that land of being seized, okay? Next definition that we've got here, when an individual is either physically detained or submits to authority, or where a reasonable person would not feel free to terminate the encounter with the police, okay? And this involves intentional conduct on the part of the police. What's difficult here is when a reasonable person would not feel free to decline the officer. Okay. I think, in one sec. Yeah, reasonable person. This is where things, it's just 2 words here, but it's a huge, huge topic. When I went to law school, and I remember reading about the reasonable person, and we've got a couple of lawyers in the room, and we've all learned about the reasonable person. But when I went to law school, when you went to law school, was it the reasonable person? Or was it the reasonable man?
Actually, right, it was a reasonable.
Yeah. When I was in law school, it was all the reasonable man, okay? And this is progress. We now talk about the reasonable person, okay? But who is that person? When we talk in law about the reasonable person, it has been historically a person of a certain gender who looks a certain way with a certain skin color. That's the way it has always been, okay? And the Supreme Court has been very reluctant to expand this definition of reasonable person to include people of different ages, experiences, races, backgrounds. When we talk about confession law, there are times where the U.S. Supreme Court is willing to take a look at the difference between an adult being interrogated versus a child, 15, something like that. But that's the court very cautiously willing to do that. When it comes to seizures, though, it just has this one person. That's the reasonable person. It's a reasonable, innocent person who looks a lot like the judges. That's just the way that one works, okay? It doesn't have to be that way. And for those of you who have copies of the slides, I added this slide this morning. I wanted to show you this. This is a quote from a case called People v. Sum from Washington State from 2022. This is not Michigan law, but this is Washington law. For those of us who are Fourth Amendment junkies, we are really Washington Supreme Court junkies as well. The Washington Supreme Court, when they talk about seizures, they don't use a reasonable person standard.
This is the standard they use, the objective observer. The objective observer is aware that implicit institutional and unconscious biases, in addition to purposeful discrimination, have resulted in disproportionate police contacts, investigative seizures, and uses of force against Black, Indigenous, and other people of color in Washington. How about that for the other end of the spectrum, you okay? Now, how can they do that? How can Washington State have that standard when we're talking about the Fourth Amendment?
Because the Constitution is the floor.
They're interpreting their state constitution, okay? They're saying our state constitution, here's the Fourth Amendment, the floor. What they're saying here is our state constitution provides greater protections to its citizens than we want the Fourth Amendment to. And, you know, that's why I think it matters, you know, who's on the state Supreme Court, depending on your perspective. I'll give you an example we have from Michigan, not in the context of the Fourth Amendment, but the US Supreme Court says you cannot lock up children for life without possibility of parole. You can't mandatorily take a kid and lock them up without life without parole. The Michigan Supreme Court says, well, that's great under the US Constitution. We take it a step further. You can't do that with 18-year-olds under the state constitution, and the court is now considering 19 and 20-year-olds, whether or not those people can get locked up as well, okay, for life, mandatorily. The point is, you can do a lot with the state constitution, and this is an example, okay? But we have that definition of seizure. Okay, the authority for seizures, if we have a custodial arrest, we need probable cause, we've already talked about that. If we're talking about something called a Terry seizure, and I know many of you have heard of Terry, we're dealing with something called reasonable articulable suspicion. And the Supreme Court says over and over and over and over again that the officer's, subjective motivation is irrelevant. So the officer might be saying, I'm gonna pick on Chris here, I wanna arrest this person here because I just don't like people with shoulder length hair, sorry, right? That's my thing, okay? Doesn't matter. If I dislike you in my heart, if I don't like the way you look in my heart, it doesn't matter as long as objectively speaking, we have either probable cause or reasonable suspicion. Because the Supreme Court says we're not gonna delve into the hearts and minds of officers. Now, a lot of that law was built up at a time before we knew what we know now about implicit bias, okay? But that's what the law says, okay? Now, in terms of Terry, it permits a brief seizure short of custodial arrest. The officer can also, if they have suspected the person is armed and dangerous, can also frisk that person. That's an open-handed pat, looking for weapons. And it's got to be suspicion that the person is armed and dangerous. If I make a Terry stop, okay, because I want to inquire because I think that you might have drugs on you, okay, I can't frisk you. I've got to have suspicion that you are armed in order to conduct that Terry frisk, okay? And I can also frisk a car. It's a little awkward to think about it that way, but a frisk includes the ability, if your person is coming from a car, the frisk includes the ability to frisk the interior of the car for those weapons. But again, it is a search for weapons. Okay, what's reasonable articulable suspicion? It's less than probable cause, some minimal level of objective justification according to the Supreme Court, a moderate chance of finding evidence of wrongdoing, okay? And I go back to this scale that we saw with probable cause. If probable cause doesn't have to be 50%, usually it is. If there was a way to quantify it, reasonable suspicion can be less. Okay, it's just less than that. And in terms of what's reasonable suspicion, I've got some examples for you. Terry itself involved a situation where an officer saw some people casing a jewelry store. The court says that's reasonable suspicion in Terry v. Ohio. We also have, individualized suspicion matching a known drug courier. This one gets a little flight from police in what the U.S. Supreme Court calls a high crime area. There are two things here. It is not just presence in a quote-unquote high crime area. It is saying, I see the police officer, I registered that you're a police officer, and I'm headed in the opposite direction. That, according to the Supreme Court, is reasonable suspicion. Now, in Michigan, we have a case called Shabazz where our Supreme Court has decided the opposite, because again, there's an example of us providing more protections, but that's as a matter of Fourth Amendment law, what that says. Where don't we have reasonable suspicion? Knowing of and speaking to drug dealers. This is Cibron v. New York, or no drug users, sorry. This is a case where police followed this poor man, Mr. Cibron, all around New York City. And all he did was, like, he had a cup of coffee with this known drug user, and a cup of coffee with that known drug user. They spent all night, you know, kind of chasing him around. And at the end of it, they stopped him, and the Supreme Court said, just because you know people who are using drugs, they're not using drugs when you're talking to them, that's not reasonable suspicion. And we also have this language about bald and unilluminating assertions, Florida v. JL. That's an interesting case. The tip the police received there was, if you go to, it was either a bus station or a bus stop. If you go to the bus station or bus stop, you'll see a young black man, I think it was a teenager, like 18 or 17 or something like that. He's wearing a plaid shirt, he's got a backpack, and he's got a gun. Police went to that location, they saw a young black man, they saw he was wearing a plaid shirt, he had a backpack, and they stopped him and frisked him, and lo and behold, he had a gun. Okay, so the tip turned out to be right, but the court said that's a bald and unilluminated assertion. Any of us could be calling in that kind of tip on one another, right? Okay, so the court says that's not enough for a tip. Okay, so what's the remedy if you have an unreasonable seizure? Any evidence obtained has to be suppressed, okay? So if you don't have reasonable suspicion for that Terry stuff, the fruits can't be used by the state. If you don't have probable cause for the arrest, then the fruits from, for instance, the search incident to arrest can't be used against the person, okay? That was a whirlwind of the Fourth Amendment. Now let's start talking. I've got hypos, okay? You guys still with me? Okay. Hypo 1, officer stops driver for speeding. After issuing the ticket, officer asks driver for consent to search your car. Driver agrees. Can the drugs in the trunk be used against the driver? What do you think? Is anybody bothered by the fact that our speeding, our moving violation morphed into a drug case? But yes and no, some people are, okay.
Yeah.
Okay, why are you bothered by Mary?
Well, I think there's privacy in the trunk of your car. And it's outside the
But-
wingspan, and I don't think that consent for, search of the car included the trunk, as you said earlier.
Okay, well, I'll change it. Let's imagine the officer expressly says, can I search the trunk? And the person says yes. They've waived their rights.
For inside of the car.
Okay. Go ahead.
More has to be done.
More has to be done. Tell me what that means.
So you have to establish who is in control of the vehicle and who has the expectation of ownership of the vehicle. So let's say that vehicle is registered to you,
Yeah,
but this gentleman is driving your vehicle.
yeah,
How do you know you put that in the trunk?
okay.
And then you have to articulate what's the link between the drugs and the person that is really operating the vehicle.
Okay, so let's take that and play with it a bit, okay? Let's imagine that the person it is my car, I have ownership of it, but the person who's driving it is not on, I was gonna say the deed, but not on the title, okay? That person does not own it. I lent the car to my friend, okay? And so my friend, the driver's gonna say, hey, I didn't put those drugs in the trunk. Whose issue is that?
That is the driver's, because the driver has control of it.
Mhm.
However, that issue that the driver now brings up with the defense becomes an arguable point in court between the defense attorney and the prosecutor. So it's not necessarily the executive branch that is dealing with that problem.
Right.
Now, the judicial branch has.
Okay, it's not a Fourth Amendment problem.
Correct.
Okay, so what is it? It's a problem, an issue of proof. Okay, it's an issue that, as you say, the judge is gonna have to deal with because the parties are gonna make those arguments. But purely from a Fourth Amendment perspective, from a Fourth Amendment standpoint, there's no problem here. And, you know, when I used to teach Crim Pro, people would say, well, how can a speeding case turn into a drug case? Easily, okay? Because the officer can always ask, and at least according to the court, you as the driver can always say, no, thank you. I would prefer not to, because a reasonable person, remember that definition of seizure, a reasonable person can feel free to decline the officer. Now, I think about the times I've been pulled over, and I remember them as times like I'm shaking and I'm holding the steering wheel. I'm not one of those people who is cool and collected under those types of situations, but at least according to the court, some of us are. The reasonable person feels free to decline the officer's request. Pardon me, what?
And they should, you should never say yes to
Right.
a search.
Yeah, oh, well, I'm with you on that one. I've tried that with my clients, it never works. Yes, sir.
My question is about the, after they issued the ticket,
Uh-huh.
are they elongating the stop? Why did this come afterwards?
Okay,
You know, if they got a drug dog there before the end of the ticket, you know, they could probably do something then, but.
Oh, okay, I'm gonna go to hypothetical number 3. Okay, you've read my mind, or you've been reading Supreme Court case law. Okay, this is hypothetical number 3, which is kind of the same. Officer stops driver for speeding after issuing the ticket. So I'm gonna come up to you saying, here, sir, is your ticket. Any questions? You sign it, you go through that process. Then I say, I'd like you to wait for the K-9 unit. Just 5 minutes, they're 5 minutes away. Okay, the K-9 goes around the exterior of the car and alerts on the trunk in my hypo. Can the drugs in the trunk be used to prosecute the driver for a drug offense?
Can the driver say, I don't wanna wait?
Okay, well, can the driver say, I don't wanna wait? What do you think?
Yes.
Yes, okay, a person can feel free to decline the officer's, request. Now, what makes this person think that they have the authority to say no? What on these facts? What would the reasonable demand?
The ticket's been issued, the seizure is over, the ticket's
Okay,
been
right.
issued.
Okay, right, so the authority for the seizure, remember, anytime we're searching or seizing, there's got to be some Fourth Amendment basis for it. Okay, so when I got pulled over, when the driver got pulled over for speeding, we had authority for that stop. We had probable cause, the officer saw the person speeding, okay? Then we write the ticket, we hand them the ticket, the authority for the seizure is now over. So to continue to keep that person here, I need to have some new authority for the seizure. Now, it could be that when I return to the driver to hand them the ticket, suddenly something else happens, a bag of meth or something like that. Then the situation turns into something else. But this fact pattern doesn't have this. I'm handing the ticket to the driver. My authority to seize you ends, but I'm just saying, hey, as long as we're here, let's hang out for another 5 minutes so we can get a drug dog here, okay? That 5 minutes is 5 minutes of a seizure that is not based on any authority, and so the fruits would have to be suppressed. Now, in this situation, we have 5 minutes, okay? Let's imagine this, and I think I'm taking your question and kind of going with it. Let's imagine that as I hand you the ticket, I've got my leash here, and I say, I'm handing you the ticket, and my partner is walking the dog around the exterior of the car as you and I are finishing up the ticket business. Is there a problem there? No, because they're contemporaneous, they're happening at the same time, okay? Now notice what's going on here. The dog sniff is not a search, right? The dog sniff in a public space, we talked about that.
Open air.
It doesn't become a search. The problem here is we are seizing a person without authority. Isn't this fun? It's kind of cool, huh? Okay. Does that answer your question? Okay. I'm gonna go back to, I wanna say, hypothetical number 2. Officer stops driver for speeding. As he hands the ticket to the driver, he sees a baggie of white powder on the dashboard. What does the officer have at this point?
Plain view.
Well, he sees it in plain view, right? Okay, and he may have probable cause, right? Can he search the car? If so, where and under what principles?
Wingspan.
Well, okay, so when we talk about wingspan, we're talking about an exception involving an arrest, okay? Good. Lynn, you look like you're gonna say something. Always ask the lawyers the question. Okay, yeah, sir.
It's probably about the plain view of the rest of the car, we can press, or the officer can press. Because like at this point, the officer's seen something, so like, you can't go in the trunk. But
Okay.
you can go in the rest of the car.
Well, let's unpack what the the officer seen? The officer's seen something that he believes is cocaine in my, we have a baggie of white powder, could be powdered sugar, could be, okay? But does probable cause require certainty? No. So how would you describe this officer's suspicion? Probable cause? Okay, if you have probable cause to believe that evidence can be found in a car, what can you do with that? Under the automobile exception, you can search wherever your probable cause takes you. You don't need a warrant. So, can this officer search this car? Yes. Where can he search the car? The whole damn thing. He can search the whole car. Because I think that the case law says he has probable cause to believe there are drugs in the car, and so that will get him into the trunk, that will get him into the glove box, that will get him into closed containers. That probable cause will drive him there. Okay, so that's one way that he can search the driver's car. Kath mentioned wingspan. Where does that come into play?
In an arrest and a seizure.
Okay, if I arrest the person, I say, is this your baggie of white powder? And the person says yes. I say, is this cocaine? The person says yes. Very cooperative person in my background. Okay, I've now arrested them for drugs. I can search their wingspan, which is going to include the actual car. How else can I search the car? Based on what you've learned today. Inventory search. Okay, so I'm gonna arrest this person, I'm gonna take them down to the jail, we're gonna impound their car, and according to that inventory code, I'm gonna follow that, and it's gonna tell me how far I can search in terms of the car. I just need to follow the inventory code. So a bunch of different ways I can get to the same result. Okay, questions? Okay, we did 3. Driver is sitting in a parked car in an apartment complex parking lot. Police receive a call about the driver. Police have frequent reports of crime in the lot by non-residents. Officer approaches the driver and asks for ID. Driver declines and drives away. Were driver's actions lawful? Think so. Okay, this is from a case from the Michigan Supreme Court, I want to say last summer. People v. Prude.
Is that in Ann Arbor?
At Grand Rapids. Okay? Did the driver do anything wrong here by driving away? Okay, so how would you describe the officer's suspicion?
History and description.
Well, he has a bit of a hunch. Hunch is not enough, okay? But what does he have a hunch of? Pardon me? Mary's shaking her head.
This person may commit a crime based on this
Okay.
apartment.
Right, based on, well,
Reports.
we've had reports in this parking lot. This person doesn't seem to fit my sense of who should be hanging out in this parking lot because, he's a non-resident, okay? According to my facts. Probable cause and reasonable suspicion are what we say individualized. It's not, hey, you happen to be sitting here and this is a bad place and so now I'm gonna arrest you. It has to be that I suspect you of committing a crime or going to commit a crime. Does this officer have any suspicion that this person might commit a crime based on this person's actions or what they've done? No, it's just kind of wrong place, wrong time.
Can you run the license plate?
Pardon me?
Can you run the license plate?
Okay, can the police officer run the license plate? Okay, yeah, we talked about the license plate readers, the automated ones, but as I'm driving down the street, can an officer run my plate?
Well, I mean, in this situation,
this-
to determine they're not a resident there.
Yeah, well, okay, well, they could do that to determine they're not a resident, or let's imagine he talks to him and says, do you live here? And the guy says no, and I think that's actually what happened there. Yeah, and there are 2 questions that flow from this. First of all, can the officer approach the person and say, hey, buddy, see you sitting here in this parking lot, what's going on? Can he do that? Yes. Okay, the 4th Amendment doesn't care about that. The 4th Amendment only cares about searches and seizures. So an officer walking up to you as you're sitting in a parking lot saying, I see you're parked here, what's going on? Are you seized? No, not according to those definitions, and you're certainly not being searched, right? So that's perfectly, okay. And, you know, we do want, if you, hopefully people agree with me, we want officers to have the ability to investigate what they see in front of them. So the officer can certainly approach that person and ask that. What about running his plate? My license plate, you're running my plate, doesn't that feel intrusive? Oh, well, is it in plain view, or, okay, is it even a search? No, do you have an expectation of privacy in, that society's prepared to recognize as reasonable in your license plate? No, why not? Because the point of a license plate is so people can see it, right? It can tag your car and know who in fact you are. So you can't claim an expectation of privacy. And they've not interfered with any sort of constitutionally protected area. Same thing, what about a VIN number? Expectation of privacy in a VIN number, if I come up to your car and write down the VIN? No, that's not a search, okay? There was a couple of questions, I think I hand up, sorry.
Where does the line, like, what if he pulls up behind me and turns on his lights? I expect it to stay then, I mean.
Okay, so where if he pulls up behind you and turns on his lights? To answer that question, which is a great question, what do you all defense attorneys want to know?
Did that reasonable person feel like they could not flee?
Okay, what do you want to know to answer that question?
What's probably the cost of the lights to be turned on?
Well, do you need to have probable cause to turn on the flashing lights? Are you talking about like headlights, or are you talking about the,
Let's go the,
okay, what do you want to know to answer that question?
Gotta be some reason. You just can't stop, the authorities cannot stop a person for no reason whatsoever.
Okay, they
Just
can't,
because they have a feeling they wanna turn on their lights right now.
they can't seize a person.
Well, I think stops are also suspicious.
Okay, well,
And
we
then just
don't,
asking for the ID is a very dangerous situation right now.
okay.
When we have these massive sweeps going on.
Mhm.
And so, you know, let's discuss that.
Okay, so I want to get to the ID. I want to answer his question. What facts do you need to know to answer that question? Don't you want to know where his car is? I can come up with facts where I'm parked in my car and an
Lawfully
officer comes
parked.
up behind me and I'm blocked in. If I'm blocked in and I seized,
Yes.
absolutely. I can also change the facts, and if we had a whiteboard, we could draw it here. I could have facts where the officer parked behind me and I'm not parked in, and I'm gonna have a hard time arguing that I'm seized. Okay, so we need to know, those facts. Now, you talked about the lights. Let's add the lights here. When the officer pulls up behind me, and when you said lights initially, I was thinking about like headlights, but let's
Or-
think about,
Yeah.
well, is there a difference?
Yes.
There's
Is there
gotta be a
diff-
difference
yes.
between
Is there a
When you
spotlight
see
and.
police officer lights, you're expected to
Okay.
pull over
Okay,
to the
is-
side of the road.
Is there a difference for the seizure analysis? Yes. Okay, so if an officer pulls up behind me and flashes his headlights or turns on his headlights, I think it's a harder argument to say that I'm seized. When an officer pulls up behind me and the lights above the car are on, then I think that I'm seized, okay? Because a reasonable person would not feel free to decline the encounter. But I also want to know some information about how that car is parked, okay? And where the car is, because that will go into the seizure analysis. I wish there was always a bright line, and there are some bright lines. You put me in handcuffs, I'm seized. But things that short of it, I think that we can get into some gray areas. Now, Mary talked about ID, asking people for identification. We are not a stop and identify state. Some jurisdictions are, where officers have the authority to ask for identification, and the refusal, it constitutes its own violation. We are not. So one of the things that was important here, in the Prude case, is when they asked for ID, he just very politely said no, and went on his way, and that's okay, because there's no law in Michigan that requires him to produce the ID. Fine? Yeah? Okay, couple more? Still with me? Okay,
I don't wanna get into complexity here, but
yeah.
will the state of Michigan be required by our current federal authorities to have an ID requirement because they are doing these massive sweeps And any policy that does not command, stop and ID production, give evidence of being a sanctuary, city or state.
Wow, there's a lot to that.
Yes,
Okay.
there is.
Okay, so I don't know that the state of, I don't know that the feds can require the state to enact an ID law, a stop and ID law.
Isn't the ID thing a court-made law, common law in Michigan? It's not a statute.
We have no stop and identify law. So if an officer comes up to me and says, I'd like to see your identification, and has no other suspicion, we're not talking about suspicion of anything else, and I say, no, thank you, officer, and walk away, as Mr. Prude did here, and you know, he didn't flee, he didn't hit the officer, nothing else like that, I just turn and go, that's perfectly allowed, okay, because there's no law that requires me to produce my identification. Can the feds require us, the state of Michigan, to enact a law like that? The only thing I can think of, well, that's a federal law, and our state officers would have to be following state law.
You can't get your federal grant unless you have
That's where it kind of comes in, right?
procedures.
Right,
How that
you know,
goes.
the money for the roads is tied to the enactment of a law or something like that. That is the way that that possibility could work, okay? 5, we've already talked about this, but as part of a routine inspection of a rental property, inspector sees cocaine and drug paraphernalia on a kitchen table. Can he seize the cocaine and paraphernalia to give to the police? Or can the police get a search warrant for the rental based on the inspector's report of what she saw?
Yes to the last one.
Definitely yes to the last one, okay? Because the inspector can always share the information with the police, okay? In terms of the inspector's ability to take that cocaine, what would you look to in terms of the authority for that?
Contract.
The contract, somebody said the
lease?
contract?
I don't know, is that in the lease?
Well, I would look at the rental code, I would look at the ordinances, those types of things governing the role of the inspector and what the inspector can and cannot do. Okay, it's not going to be between the lease, between the tenant and the landlord. You're never gonna sign a lease, don't ever sign a lease that says, if you find contraband in my house, you can take it, don't sign that lease, right, okay? But it depends on the inspector's authority. But even if the inspector doesn't have the authority to take those drugs, they can certainly report that to police. Police could then go get a warrant based on what they got from the inspector, okay? Officer arrests driver on a warrant for failing to appear. Can the officer search the driver before putting in the patrol car under what principles? Did the officer search the car under what principles? Let's talk about searching the driver.
Terry Pat.
Officer safety.
Okay, can the officer search the driver? I think everybody's kind of gets the sense of yes. The question is, what's the authority? The officer has arrested the driver. They can conduct a search incident to arrest, okay? And it doesn't matter what that underlying warrant is. It's the authority to make the arrest. So you can arrest me for 15 murders. You can arrest me for tax evasion. Okay, we might think that those two crimes are different levels of dangerousness. It's the authority to make the arrest that authorizes the search, okay? And so the officer can clearly search the driver, okay? Can the officer search the driver's, well, before we get into the second question, is there any other principle that they can search the driver? Might be, that's the rationale for it. It could be part of an inventory search as well, inventorying the person's belongings, but it's generally gonna be a search incident to arrest. Can they search the car?
Inventory.
They can search the car under an inventory. They can search the car, depending on maybe the circumstances of making the arrest, under the search incident to arrest, if that person's a recent occupant of the car and has a chance of accessing it. So multiple ways to get to the same evidence. And I got one more here. I think, oh, look at that. I think I'm making it just in time. Officer stops driver for speeding. Driver tells officer she drank 10 shots in an hour before she got in the car. Does the use of the driver's statement at a later criminal trial violate the Fourth Amendment?
I don't see why it wouldn't.
You don't see why it wouldn't, or why it would? Oh, I'm sorry.
I miss it.
Okay, the Fourth Amendment protects us, or against unreasonable searches and seizures that result in tangible physical evidence. Okay, what we have here is a statement. The protection that this driver might, in theory, have is under the Fifth Amendment. And the Fifth Amendment says the state can't turn us into witnesses against ourselves. That's what Miranda's about, right? The Miranda warnings that you've all heard on TV, we're telling people, hey, we can't turn you into a witness against yourself, so know what your rights are, and if you want to clam up, you can, okay? And then the person can talk or not. Okay, but here, you have no Fifth Amendment right to be given Miranda warnings by the side of the road, and so this driver's statement comes in, it's not a Fourth Amendment problem. We only care about the tangible physical evidence, okay? Ton of Fourth Amendment, and I've got 9 minutes. Questions? Any questions? Yes, sir. Yeah.
Related to effects, thinking like, okay, so an effect would be a cell phone. The cell phone has it so that notifications or messages are plain text rather than hidden. Are those considered plain view and not requiring a warrant?
It's a great question, okay? What if police officers arresting me, and as part of the arrest, nothing untoward, okay? I'm holding my cell phone in my hand, and my phone starts alerting. Come meet me to buy the cocaine in the address, okay, or something like that. Can the officer use that information? Is that essentially what you're asking? Yes.
The question is dependent to the public or in the private privilege location?
Where the
Where the cell phone was at too, where they're reading it?
Okay, it depends on the circumstances where they're seeing the cell phone. So the officer is arresting me, I'm holding my cell phone, it's flashing. Come buy cocaine at the Hannah Center, or something like that. You're the officer, you see that. That information is essentially in plain view, in plain sight, right? So you can act on that information. What you can't do though, is go into my phone, crack open my phone and start exploring its contents. Because the Supreme Court says this type of container requires a warrant, okay? Now, the other thing you can't do is, let's imagine you're arresting me right here, and you see my phone is flashing, and you say, okay, I wanna see what messages you're getting. Open up the phone so I can see the messages. Okay, that becomes a problem, because that is a search of my phone, and you don't have an exception that authorizes it. Could I say, officer, I'd like to show you the alerts I'm getting on my phone directing me to the Hannah Center to go buy cocaine? Could I do that? Yeah, I could do that, right? But again, I'm waiving my rights.
But later becomes, they're able to search your phone when it comes in an inventory.
Okay, they're always going to need to go get a warrant for a phone.
Even when in inventory?
I can't speak for every inventory code of every municipality nationwide, but my understanding is phones, warrants, okay? There's too much in a phone. Think about what's in your phone. Oh.
Would it make a difference if, say, I'm walking past this purse and I see drugs right there, or I'm walking past this purse and I go and then see drugs?
Okay, well, there are a couple of different things that you just did, okay? And I'm gonna grab my purse here. Okay. So, I'm gonna try and put this here. Here, my bag is open. Everybody see? Bag is open. Hopefully it'll stay up. Oh, okay. Let's imagine it's up and open. And I'm standing here lawfully as a police officer and I see inside that. No problem, plain view. Now, the question is, that's my knowledge that I gained because I looked inside the bag and I saw the baggie of white powder, right? I see something that I know on site is contraband, okay? What can I do with that information? I'm just gonna put it this way, now I can see it. Okay, what can I do with that information as the officer? I could go get a warrant with it. You can always go get a warrant with the information. But if I wanna search that bag, what do I need? I need some exception that applies, okay? And we've only gone through some, but I'm gonna need some exception. Now, change the facts a bit and I'll get to the other part of your question. I walk past the bag, I don't see a baggie of cocaine that's white powder. I see this. I don't know what's in here. Can I open this up just to check to make sure it's not cocaine? No. Okay, what is this when I do that? When I reach inside, I'm searching. I'm interfering with an expectation of privacy, or I'm trespassing on a constitutionally protected area. And so the act of pulling this out is a search, and I have to have some, either a warrant or an exception that applies. Okay, now, the fact pattern that we've talked about, I'm standing lawfully here, I'm the officer, and I see that. In the second part of your hypo, the officer manipulated the bag to see inside. Does that change the situation?
It's not.
It's not? Well, what is the act of manipulating the bag?
It's not.
It's a search. It is an interference with an expectation of privacy. So in the first hypo, the bag is open, I can see it. In the second hypo, it's closed, and I just decide to open it so I can get a better eyesight, okay? And then change the facts again. So let's imagine that as part of what I'm doing, the bag falls and everything spills on the ground. And it's truly inadvertent and an accident that the bag spills. I don't do it on purpose. Is that okay? It's not gonna be a search then, okay? But if I say, oh, I wish I knew what was in this bag, I wish I could find out what was in this, oh, look what's in this bag, I found out, right? That's a search. What is it? Yeah, Eric, you.
What if the bag is in the car?
Where in the car? Where am I? Where's everyone?
Bag's in the passenger compartment, so you've got the powder, you've got the white bag on the dash,
Yep,
right? You've got the automobile exception that gets into the car.
okay.
Is the bag part of the car?
The bag is part of the car. When we're applying the automobile exception, probable cause takes you anywhere, it gets you anywhere your probable cause would take you. So you have to go back and inspect the probable cause. I have probable cause to believe there are drugs in this car. That gets me through the entire car. It gets me in the trunk, it gets me in the glove box, it gets me into closed containers included in the car. Let's imagine my probable cause is that the person is transporting a dead body, a dead human body. Do I get in the glove box? No, no. So you always, when you're dealing with probable cause, you always have to go back and inspect the probable cause and say, what is it for? Because it will dictate the terms of where you can go.
And the baggie, your second type of the baggie only gets you into the car because of the automobile exception, right? Because otherwise you have to go lower. If it were a baggie in the house.
If it was a bag, well, how would I know about your bag in the house?
Because
Let's-
you live in the same house.
Oh, okay. Well, let's take this hypothetical. Let's imagine that in terms of a bag in the house, I'm the officer. The reason I know about the bag in the house is I walk through your flower beds, walk up to your window, shine a light inside your house, and then I see a baggie on the coffee table. When doesn't it work? What does it mean?
You have no authority to be there.
Okay, so what is the act of walking up to your window and going and shining a light inside your house and looking at the coffee table?
It's the same one with the dog sniffing on the front porch.
It's a search, right? Am I interfering with an expectation of privacy? Yes. Well, you have windows in your house. You know the answer. You have windows in your house. Do you expect people to walk up and put their noses against their windows? No. The windows are for illumination, not for people to snoop in that way.
But if you get into my house because of a domestic, right?
A
so you
lawful,
show her-
yeah.
So then there's a baggie on the coffee table, that's in plain view. You can't search the house based on that, you need to get a warrant because it's my
Okay,
house.
so I come over to your house, I get a police call. I come over to your house, in interacting with you legitimately in this call, see the baggie on the coffee table. What can I do? Can I search the whole house? Well, can I grab the baggie? Let's start there. Okay, based on what? Plain view, lawful vantage point, right? Lawful vantage point, do I have probable cause? And do I need to engage in further search activity? No. Change it a bit. Let's imagine that I can see a corner of a baggie, but the baggie itself is covered up by this paper plate. I'm not quite sure. I just want to move the paper plate a bit to get to the baggie. Is that plain view?
No.
No, because the act of moving the plate
It's a search.
is a search, right? And actually, it's very close to the facts of Fortin v. California that gave us that case. So, but if in the situation where I come here to your house legitimately, I see the baggie, nothing else on the coffee table, I can take that baggie in plain view. Can I start wandering around your house and let me just look in some more drawers? Because, you know, where there's smoke, there's fire. If it's got cocaine on the coffee table, it's all over the place. Can I do that? Okay, the court is gonna say warrantless activity in the house is presumptively unreasonable. What the officer should do in that situation is shut down the situation, get the person out of the house, and then apply to go get a warrant and go from there. But if I take that baggie on the coffee table as a license to go wandering around your house, I think anything else I find in that house, unless I've got an exigency, which we've not established here, I think that all that other evidence would be suppressed. Okay. Yes, sir.
I would like to shift the focus of the questions here a moment, because it in some ways it almost sounds like we're a bunch of drug users and drug smugglers asking all these technical questions about how to stay out of trouble. And
I don't think these are hypotheticals, yes.
Yeah, I know, but I have no use for druggies. What I want to know about is, okay, I am a person who almost 40 years ago got bounced off a jury selection because I said I would trust the word of a police officer over that of a civilian.
Mhm.
So I was out. In the last 40 years, I've learned a lot of things from personal experience and from that of friends and acquaintances, and I would still trust the majority of police officers, but I would know that for a whole bunch of reasons, not all police officers can be trusted, and some are quite nasty, spiteful, or corrupt. I want to hear from you, from your knowledge in dealing with cases, or from your peers, or accounts you've read, of how ordinary people have wound up in trouble with the law because of violations of their Fourth Amendment rights, even if they were absolutely, positively not really guilty of any crime, didn't have any kind of illegal substance or anything like that. And also of situations where people may have been exercising their right to protest publicly at demonstrations,
Okay.
or have materials at home, like lists of people who they were engaged in political activity with, who had their Fourth Amendment rights violated by the police or other government agencies in some way, and how they dealt with that, because that may be a
Okay.
problem in the near future.
Okay, so in terms of protests, let me say this, I've given, and we're right at the 12 mark, and I'm happy to stay to answer any questions, but, there is a sheet that I provided from the ACLU, which I think is up to date about dealing with protests and interacting with officers in protests, and I would suggest everybody take a copy, take a look at it, read it. When I think about my clients and the difficulties that they have gotten themselves into, and I don't have any history representing protesters. Virtually all my clients have been convicted of homicides. Their big problem is they consented to searches. And I can't think of a search where the police officer did anything wrong. I think if anybody did anything wrong was my client consenting to a search and saying, sure, I have a bag full of drugs, why don't you search it? People waive their rights and people consent, and that gets them in a ton of trouble. But again, the law says that consent needs to be free from coercion or duress. So as long as that officer didn't threaten my client or didn't hit them or hurt them in any way, they ask and my client consents, then it's okay.
Any cases coming up on the Supreme Court that you have your eye on?
The cases that, not in terms of Fourth Amendment, the cases that I have my eye on from the Michigan Supreme Court are cases about juvenile lifers, where the court is considering extending those protections, not locking up children for life to 19 and 20-year-olds. Michigan has a very, very progressive Supreme Court in that regard, and so that's what's going on, yeah.
To your earlier point on, the police can see you because they visibly view you speeding.
Yeah.
How is that in relation to, like, let's say with digital surveillance cameras able to catch people after the fact, and police compared with AI has caught you?
You know, that is a new frontier, right? You know, the question is what happens when AI catches the person instead of the officer? That's a new frontier, and we get into questions about the reliability of it. You know, I don't know anything about that particular technology. I have played around some with ChatGPT. I don't know if other people have as well. It's crazy unreliable. I was looking at it a couple of weeks ago and I said, you know, give me a quote from a Supreme Court case about this. And it gave me this beautiful quote and a case citation. It didn't exist. It made it up. So, you know, caveat emptor. So I know that we're noon. I'm happy to stay and answer questions, but I know people need to leave. Thank you very much for coming. Thank you. But I'm happy to answer questions.